has spoken. My client, Maryanne Kitany, had filed a matter to prohibit the respondent, Senator Honorable Mithika Linturi, from evicting her from her property in Runda, which she built by her own self, property that her children and the senator's children have been residing in. She was unlawfully evicted. The court returned her back to their house. Now the court has confirmed that she is now rightfully present and rightfully in her place of residence. The court has identified the vulnerability of women who are in a relationship that has schemed to be a fraud. My client was called a visitor who had overstayed for over 10 years. My client was called a person who needs to be evicted without due process. The court has upheld the position of women in such a relationship. The court has relied heavily on Section 4 of the Protection from Domestic Violence Act, where the law in that provision says any relationship, whether married, whether for sexual purposes, whether for anything, anybody who is in a relationship akin to a domestic relationship must be protected. And therefore, the court has gone back and clawed to the Bill of Rights in the Constitution, said that my client's rights, fundamental human rights, must be protected, regardless of whether, what status my client is. My client has been called a slave queen. My client has been called a visitor. My client has been called any bad adjective that is associated to male chauvinism. The court has moved up and agreed that regardless of the terminologies the respondent will assign, this is a decent human being, and that decent human being deserves the protection of the law on equal measure. And this is a landmark decision that will go a long way to protect so many women in this type of traps, where the men have trapped them and therefore they move ahead, enter into their relationship, and for the purpose, not for a relationship, but for the purpose of defrauding the properties the hard-working women, the career women of this nation are facing. And therefore, this matter is a landmark decision for the protection of the marginalized group, called the women, and especially career women who have fallen into this trap. And therefore, my client is very happy that now she's settled, her children will go to school, everything will run normal, and thank you very much for the nation to having stood firmly behind one of their own to protect the rights of the women. The magistrate, we appeared before Honorable Orenge, who has given the ruling and the judgment, and therefore we are comfortable, unless there is any questions from the press. Joe?
Application for stay, and in view of the sentiments that I've already expressed, that there is already another order which is before the High Court, I will not grant any stay, but if the respondent is desirous of that order, they can file a formal application for consideration of the court. The applicant may not have been allowed in the register in this House number 16. Having made such a finding, then I have to make a finding as to whether this applicant now merits to grant the orders that she's seeking this morning. I have extensively relied on the American case scenario and then the Supreme Court of India cases, and the applicant had supplied me with the constitutional case 29 of 1999, State versus Court, and the court has relied on the case of the Muswami versus China, and in front of society, it must be of valid legal age of marriage. Then they should qualify to enter into a marriage. None of the partners should have a spouse living at the time of entering a relationship. 4 and 5, I've been in these courts. They must have voluntarily cohabited for a significant period of time. Then number 5, they must have lived together in a shared household. People in such an arrangement, any of the parties qualifies to be granted the orders of this court. The Supreme Court of India has further observed that not all living relationship will amount to a relationship in the nature of marriage, so that a party can get benefits under the Domestic Violence Act. To get benefits, the conditions mentioned above shall be fulfilled, and this has to be proved by evidence. The applicant has already presented evidence before this court. As I have considered, and this is, of course, from the police, where they obtain the emergency protection order, and then number 2, they can. This is number 1, the emergency protection order. This can be by the police, and then number 2, the protection order, which lasts for a longer time, typically 1 year to 5 years, in extreme circumstances, up to a lifetime. A victim can move courts to renew the protection order if she still feels threatened by the abuser. Before this act came into the Domestic Violence Act has come into force in 2005, and I was at around 2015 thought of enacting the present act. And the main object of the act is to protect women from violence inflicted by a man and or a woman, because at times also women can be violent towards the men. So it is a progressive act, and the intention is to protect parties irrespective of the relationship they share. The definition of an aggrieved person under this act is so wide that it can be taken within its purview, even women who are living with their partners in a living relationship. I have given the definition of living in the Supreme Court of India case. There are several types of violence that economic abuse have given the instances under which, and some of the forms of violence that have enumerated above in my ruling, in the grounds that I have already read, touch on the present application, sorry, the present applicant. So, what orders can the court issue? A no contact provision, provision regarding contract, stay away provision, move out provision. I'm not reading because if the parties can pick the judgment and read. A move out provision, firearm provision. This particularly affects those who are licensed to carry firearm, and then counseling provision, and then provision regarding payment of expenses. The American scenario, some those cases allegedly filed by the respondent, which turned out that it was a false document. There is no evidence really that was presented by the respondent to show that any complaint had been lodged in relation to the issues that they had raised, considering the issues raised had criminal elements which can be dealt by other agencies, including the criminal investigation. In case of Speaker of Senate and another versus the Honorable Attorney General, investigation without really taking a finding at this stage. Now, finally, in the case of Krishna, but application merits the issuance of the orders sought. So I'm allowing this application in terms of Player D, 1 to 9, and then of course E, the orders that I have already issued are directed at the OCS Runda to ensure that they are complied with. Of course, the cost of this application are provided for. Now, before I finish, for avoidance of doubt, the order does not apply to children who are currently living in this Mae Ridge Villa, house number 16, or who used to live. The order shall remain in force until such a time when there are two cases, 37 of 2018 at Meru and number 71 of 2018 are completed. So that is the ruling.
And remember 71. So I would suggest that you should read.
1 second. 2018.
Case number, the Meru case number 37
Yes.
was transferred to Nairobi and renumbered 71.
Okay.
So that when your order says your release shall last until the conclusion of those two, it's actually one and the same.
Of course, you remember the last time you were arguing,
Yes.
one was saying they wanted to withdraw this, but it has not been brought to my attention. These are parallel proceedings.
It's okay.
I'm
we're
actually
just,
not aware that it has been
it's
transferred.
okay.
And
It's not a major issue. It's just so that your ruling will be coherent with the factual situation on the ground.
It's okay.
So that what I believe then your order should read is till the conclusion of the divorce case and the case number 71. Yes, the divorce case is number 26. The divorce case is number 26, Meru Magistrate Court,
26 of
2018.
Meru CMCC.
Yes. So the order there for the last paragraph you read therefore should refer to conclusion of Meru divorce case number 26 of 2018 and I call
Number 71.
71.
Okay.
Number 2
Yes.
is on the safety case. I had your honor refer to prayer DE1 note.
Yes.
And in the motion I have, the prayers are numbered using
numerical.
the Arabic numerals.
Yes.
So it is number 1, 2, 3.
Yes. Numerically, it's Roman actually. Roman 1 to 9.
So that perhaps that could be clarified also before we obtain.
It's in the ruling.
Oh,
actually, my ruling is in numerical. I have D numerical 1 to 9.
Perhaps I don't know because I don't have a D. D is the A, B, C, D. The motion is number 1, 2, 3, 4. Then there's some.
Which is children's case number 74.
2019.
Your Honor, I think then if we go that route, there are 10 cases. I don't know whether I want to list all of them.
I have only one issue. The court can listen and fine.
Okay.
There are orders that you have given about children.
Yes.
I don't think they are part of the issues on the divorce case. No. That's why I said that because this court has talked about children, I only wanted to bring to the attention of the court that those issues will be dealt with in the children's case number 74. That's all.
I think your ruling with regard to the children is clear and it shouldn't bring any case management issues because in any event, if I understood, Your Honor, your decision was that the orders you've made today do not affect the right of any of the children, whether to live or not. So your order is okay whichever one reads it as regards the children. So I don't see why we should note anything. In any event, the children court is just across the road.
I will withdraw that.
Then before I was interrupted, I don't know why my friend is laughing. I was telling Your Honor I have been instructed to apply for a certified copy of your decision today morning and the typed proceedings because the respondent would want to lodge an appeal against your decision. Your Honor will be aware that under the Protection Against Domestic Violence Act, the appeal must be lodged within 30 days. So for that reason, I would request that you issue a directive that the proceedings and your ruling should be availed.
The proceedings, my own proceedings,
Yes.
and the ruling,
Yes.
you'll have it right away because I do almost 80% of my proceedings are normally typed.
That's very encouraging.
Yeah, so maybe what you will do is like what I'm writing now is what
Yes.
you will get, which will not take a lot of time. So you don't need to belabor because
Okay.
I think my previous rulings and all the proceedings, your previous submissions, they are all
It
typed.
doesn't harm nonetheless for
Yes,
the record.
all I'm saying, you don't have to belabor because what has to be typed will not take long.
I hear you, Your Honor.
Yes.
Then I've also been instructed to apply for a stay of your decision, pending the exercise of the right of appeal. I'll leave it to Your Honor to decide if the court is inclined to grant that request, to decide if it will be a stay for how many days. That's all.
You're done.
Yes.
Here in regard to the right of appeal, that is statutory constitutional right. I have instructions to oppose and object vehemently an application for stay on the grounds that a formal application for stay should be filed for you. That has not been done. To Your Honor, the ruling today changes nothing in terms of the earlier orders. They have only been confirmed. My client, who is still in possession of the house, is the one the court has confirmed to continue staying in his home. So therefore, stay will mean change of position of my client to get out. And that is not in the spirit of this ruling. Third, Your Honor, it has been confirmed by the court itself that all the proceedings and ruling are ready. So, the delay counsel is anticipating that will make his movement to the High Court and tenable has been sorted by the court, having been kind to do its proceedings and the ruling in typed form. Your Honor, therefore, the application for stay is not merited. It is our strong conviction that there is no justified ground for an application for stay. Therefore, we urge the court to reject that application.
You think you are